Today we will talk about the concept of bail under Bharatiya Nagrik Suraksha Sanhita. It is covered under chapter 35, which includes section 478 to 496. Now, in this video, we will talk about the meaning of bail, how it is different from parole and remission, what are bailable and non-bailable offences, types of bail, and the meaning of the term bond and bail bond, and the difference between the two, and lastly, the concept of forfeiture and cancellation of bail. And before proceeding with the video, please subscribe to the channel and share it with your friends. Now, the term bail is defined under section 2b of the Sanhita as a temporary release of the person from prison during the pendency of the case. Now, this concept of bail is based on the presumption that every person is presumed innocent until proved guilty. Therefore, bail is a rule and jail is an exception. It means only under certain circumstances the court will refuse the bail and put the person into jail. And those circumstances can be where the offense committed by the person is serious in nature, or where there are chances that the accused will tamper with the evidence or threaten the witnesses during bail, on other circumstances. The term bail is often confused with parole and remission. Now let's understand the difference between the three. Now, bail, as we have studied, that it is a temporary release during the pendency of the case. It means the guilt of the person is yet not decided. Whereas, if the person is convicted by the court and he is given a sentence of imprisonment, at that time the concept of parole and remission comes into picture. Now, if the person is to be released for a certain time period due to existence of certain circumstances, it can be the marriage of the convict, any family function, death of the family member, health reasons, or other circumstances. In that case, a person can be released for a certain time period on parole. Now, in that case, the sentence of the person is suspended for that time period. But after the expiry of the term of the parole, the convict needs to come back to the jail to serve the remaining time period. Now, the period on which the person is released on parole will not be considered as part of sentence. Now, the third is remission. The benefit of remission is given when, after serving a certain time period, due to the good conduct and behavior of the convict in jail, a person is released from jail. Now, the remission is always given on certain terms and conditions. If the person fulfills those conditions, only then he can be released on remission. If the person is given a benefit of remission, in those cases, the person need not to come back to the jail to serve that remaining period. But remember that remission is given on a certain terms and condition. If the person fails to fulfill those terms and conditions, in that case, the benefit of remission can be cancelled and he can be called back to the jail to serve the remaining time period. Now, the concept of bail is governed by the provisions of chapter 35 of the Bharatiya Nagrik Suraksha Sanhita, whereas the parole is governed by state rules and the Prisoners Act, and remission is governed by the provisions of Constitution of India, Bharatiya Nagrik Suraksha Sanhita, and state rules. Now, the next is the difference between bailable and non-bailable offences. Bailable offences are generally less serious in nature. Therefore, the accused has a right to claim bail as a matter of right. It means the authorities or the court does not have a right or a power to refuse bail to the accused. Whereas, on the other hand, non-bailable offences are serious in nature and therefore the court has a discretionary power to grant bail to the accused. It means the accused cannot claim bail as a matter of right. It is up to the court to grant or to refuse bail to the accused. Now, in case of bailable offences, bail can be given by the court as well as by the police officer who is going to arrest the accused. On the other hand, in case of non-bailable offences, only court has a power to grant bail and police officer does not have any authority to grant bail to the accused. And to find out whether any offence is bailable or not, we need to refer Schedule 1 of the Bharatiya Nagrik Suraksha Sanhita. In both bailable and non-bailable offences, the bail can be cancelled only by the court and not by the police officer. Next, the concept is bail bond and bond. The term bail bond is defined under section 2D and bond is defined under section 2E of the Bharatiya Nagrik Suraksha Sanhita. As we know that whenever a person is released on bail, certain terms and conditions are prescribed which needs to be fulfilled by the person. Secondly, certain amount is to be fixed by the authorities which a person needs to give if he violates the terms and conditions of the bail. Now, if we talk about the money part, in case of violation of the terms and conditions of the bail, that amount of money can be paid by the person himself or any other person can take a guarantee to give that money to the court in case of violation of the terms and conditions of the bail by the accused. Now, if the person is himself taking a guarantee to pay back the money in case of violation of the terms of bail, in that case, the document which is prepared for the release of the accused is called bond. Whereas, if someone else is taking a guarantee to pay the money in case of violation of terms and conditions, in that case, the document is called bail bond and the person who is taking a guarantee is called surety. This is the major difference between bond and bail bond. Now, the next concept is who can grant bail. Now, as we have already discussed that in case of bailable offences, police officer or a court can give bail. Whereas in case of non-bailable offences, only the court can grant bail. Now, here the term court is the jurisdictional magistrate who can grant bail. But Court of Session as well as High Court are also empowered to grant bail if the bail is refused by the court. In such cases, a person has a right to move to the Court of Session or to the High Court. Now, both Court of Session as well as High Court have concurrent jurisdiction. It means a person can make an application either to the Court of Session or to the High Court. If the application is made directly to the High Court and in the High Court refuses to grant bail, in that case a person cannot move to the Court of Session. But if the Court of Session has refused to grant bail, in that case a person has a right to move to the High Court for bail. So the rule is that always apply for bail to the Court of Session first and then move to the High Court. Now the next concept is types of bail. Bail are of two types, regular bail and anticipatory bail. Regular bail is made after the arrest of the accused and secondly it is made both bailable as well as non-bailable offences. Whereas the second type of bail is anticipatory bail. Anticipatory bail, as the name suggests, in anticipation, it means a person is yet not arrested but the application for bail is made to the court. Now, if the court grants anticipatory bail, it does not mean that the person will not be arrested. But person is arrested and immediately after arrest he will be released on bail. That is the concept of anticipatory bail. Regular bail can be claimed both in bailable as well as non-bailable offences, whereas anticipatory bail can be claimed only in case of non-bailable offences. Thirdly, regular bail can be made to the jurisdictional magistrate as well as to the Court of Session or High Court, whereas anticipatory bail can only be made before the Court of Session or High Court. Next concept is forfeiture of bail and cancellation of bail. Now, both the terms often confuse law students, but the difference is that whenever there is a violation of any term and condition of the bail, in that case, the court can take two actions. One is to take the amount which is prescribed in the bond or bail bond, as we have discussed earlier. Now, if the court is asking for the money, in that case, we use the term forfeiture of bond or bail bond. Whereas, mere asking for his money is not sufficient because if a person has breached the terms and conditions of the bail. In that case, he need to be arrested and put it into the jail again. Now, for that, mere forfeiture of bail is not sufficient. The bail needs to be cancelled. If the court wants to rearrest the person and put him into jail, then we use the term cancellation of bail. I hope this video helps you to understand the concept of bail. If you have any doubt, please put it in the comment box.